Ladies and gentlemen, my name is Abdurrahman Garoub and my student number is 1517330. Today, my presentation is going to be on what are the challenges on distinguishing the differences between licenses and leases, also what the court have done to simplify the differentiation of the agreements. So today, the outline of this presentation is going to start by defining what is a license. Further, I will also define what is a lease and going to introduce to you what are the characters of creating a lease. And while I'm doing that, I'm going to analyze the problems on each character. Further, I'm going to critically analyze exclusive possession and its requirements and what issues that the court have suffered from. Therefore, I'm going to talk about the objective approach that has been created by the court in regarding to leases and license. Finally, I will introduce the reality of agreeing on a lease and a license. The principle of a license was created in a very old case with a very difficult approach in the modern era. The case was Thomas and Sorrel in 1673. It held that a dispossession or a license properly passeth no interest nor alters or transferred property in anything, but only makes an action lawful, which without it had been unlawful. In other words, this merely means that someone is taking permission from another to use his or her property to do any lawful action that has been agreed by both parties. A lease is a grant of a right to the exclusive possession of the land for a determinate term. This is what academics see when they speak of a lease. In order to create a lease, there must be three essential requirements. First is certainty of term. Second is exclusive possession. And finally, rent. To begin with is certainty of term. Today, the only two methods that are clear enough to introduce in this presentation are periodic term and section 1496 in the Law of Property Act 1925. A periodic term is when a tenant pays rent in installments either weekly, monthly, or annually. Section 1496 of the LPA suggests that phrases like for life or until marriage is an automatic 99-year term. So, in the case of Prudential Assurance Company Limited and London Residency Body, Lord Brown Wilkinson described the requirement of certainty of term as ancient and technical. Because it is ancient, it caused a huge legal discretion with nearly catastrophic outcomes. In the case of Mixfield Housing Cooperative Limited and Beresford, the Supreme Court nearly made a bizarre judgment, and that was transforming a lease otherwise uncertain duration into a 90-year tenancy. This judgment was taken from the essence of Section 149 of the LPA. This would have led to abolishing the requirement of certainty of term. However, this judgment was retained and held that there was no lease. Moreover, is the case of Lace and Chandler, where the court has held that there will be no lease given with the term of duration of war. It was argued it is not certain, unknowingly, when the war will be over, nor how long will it take. Therefore, in determining a duration of an agreement is open as long as it can be identified. Rent. Rent had many turnover in the past years. Whether or not at rent. These were the words written in section 2051 in the LPA, showing clearly that rent is not an essential requirement in creating a lease. However, in Street and Mountford, 1985, a key case that we'll be mentioning later in this presentation have held that rent is an essential element in determining a lease. A few years later, in 1989 and 1993, two cases have confirmed that rent is not an important element in creating a lease. And these two cases are Ashburn and Anstalt and Arnold and Company, 1989, and Skipton Building Society and Clayton, 1993, which have created a great confusion in the principle of rent regarding leases. Now, exclusive possession. Yet again, we visit the case of Street and Mountford. This case had a greater role in guiding exclusive possession rather than rent. Lord Templeman gave three requirements regarding exclusive possession. First is actual exclusive possession. Second is consideration. And in other words, intention. There must be intention for the landlord to give exclusivity, for the tenant to enjoy and do whatever he or she want with the land. However, Lord Templeman have set exceptions for this requirement, such as family arrangements, active friendship, and charity. An example for that would be the case of Cobb and Lane, where a sister have allowed her brother to occupy her house rent-free for 13 years. The Court of Appeal have held that this was a family arrangement which excludes the intention on creating an exclusive possession. And the final requirement for finding exclusive possession is periodic term. This is where it causes problems because this overlaps with the requirement of rent, where there is no need for rent, but it's hard to prove exclusive possession without rent. Because of these problems we are suffering from, many of the landlords have attempted to disguise the creation of a lease to a license. The court have been eager to tackle this problem, so it created a new approach for the situation, which is the objective approach. The objective approach began in the case of Facchini and Bryson, 1952, where the court had to analyze not only the words used in their agreement, but to see the relationship between the parties' right and intention. Later, the case of Appa and Parncliffe Investment, 1964, have came up with a solution, saying that reserving a right to come to premises alone will not abolish exclusive possession. However, this solution has proven to be not good enough. In the case of Crancor Limited, De Silva, 1986, the landlord has reserved the right to enter the premises for weekly cleaning. It was held that it was a license. So, the court had to strengthen this idea of reservation. In the case of Antoniades and Villars, 1990, on one hand, the landlord have entered a clause reserving the right to enter the tenant's premises. But on the other hand, this clause was never exercised. Therefore, the court have concluded that the landlord was trying to avoid exclusive possession in order to create a lease. Another example to the objective approach is the case of Aslan and Murphy, 1990, where the court have held that retaining a key to premises will not abolish exclusive possession, and therefore it was a lease. But the reality of this avoiding of lease into a license was only because of the numerous statutory benefits for the tenant. But is it really any good for both of the parties? Now, we're going to discuss the reality behind leases and license, and to see why landlords prefer to be a licensor rather than a lessor. First is, what are the rights in both leases and licenses? In a lease, it is a proprietary right where the tenant has full control of the land and can do whatever they want with it. They can rent it, open a business, live in it, or even he or she can sublease it to anyone. Whereas in a license, it is a personal right. The agreement is with the landlord himself, not with the land. Therefore, the licensee cannot do anything with it except using it for the purpose of what has given by the agreement. Second is how secured are they? A tenant cannot be removed from the property unless terminating the agreement. This can happen through expiry of term, notice, surrender, merge the agreement, or forfeiture. Whereas in a license agreement, it can be revoked at any time as long as it is reasonable. Third is what are the obligations between the parties? In a lease, we have the Landlord and Tenant Act, 1985, creating a relationship between both of the parties. For any conflict, it can be easily fixed within this act. An example of an obligation is Section 11 in the act that contains the repairs obligation between the parties. Also, for example, quiet enjoyment and premises fit for habitation. Someone can actually live in the premises. Whereas in a license, there are no implications whatsoever on anything. It's rather a normal contract because, again, it is a personal right. Fourth, who can they sue? In a lease agreement, the tenant can sue whomever they want, and especially in nuisance, where they can sue personnel who damage the land and protect it. Again, because the lease agreement is a proprietary right, and they own the land itself, whereas in a license agreement, it's a personal right. So you don't actually own the land itself in order to have the ability to protect it. This was confirmed in the case of Hunter and Canary Wharf. Finally, is that can you sue trespassers? In a lease agreement, you can actually take proceedings against anyone, including a trespasser. But in a license agreement, they wouldn't be able to take action and sue a third party because this is a distinctly proprietorial right. The only person that a licensee can take action against is the landlord only. To conclude this presentation, it is argued that it's better for a grantee to be a tenant rather than a licensee due to the rights and powers that they have. And it is believed that it's better for the grantor to be a licensor, but according to the evidence, it is not. Finally, it is very difficult to distinguish between a lease and a license due to the lack of certainty and the common law for this matter. Thank you.